State Representative Dan Ugaste of the 65th District. Appreciate the opportunity to talk today. As the leader said, the status of the case was the response was due from the defendant to file the brief in response to the Supreme Court's order asking us to address the issue of timeliness, whether or not this lawsuit was timely. And as she clearly stated, the Attorney General Raoul, declined to take a position on this on behalf of the State Board of Elections. This is contrary to what's happened in the past when the Attorney General has filed a brief and taken a position on behalf of the State Board of Elections. So this no position is very significant. Speaker Welch and President Harmon then intervene in the case. Their attorneys, who are Attorney General special appointments at this point, but include Michael Casper, as the leader indicated, are asking the Supreme Court at this point, through a legal technicality, to deny an untold number of voters their constitutional right to their vote and the weight of that vote here in the state of Illinois. And the technicality they're relying upon, it's called latches. It's I won't say little used, but it's not something that you come across every day. I defended cases for 37 years, and not once did I ever use latches in defending a case. But I'm familiar with it. It's a two-pronged test. First, they have to show that the plaintiffs, being Leader McCombie and the 5 individuals in this matter, were not diligent in pursuing it. They're just sort of not paying attention, not doing what they should, and were not diligent pursuing their rights or the rights of others that they're trying to protect. As we've gone through in the past, 2023 brought in a new leadership team, and if we're going to follow the U.S. Supreme Court's guidance on when these should be filed, we needed to wait for 2 elections. We filed immediately after the second election, and the results were in. Furthermore, there's 3 of 5 election cycles left, which this map involves. So pretty sure we didn't lack any diligence in this. The next prong of the test is you have to prove prejudice to the defendants. And prejudice is my focus here today mainly because in what's alleged in the brief filed by Speaker Welch and President Harmon, I don't think they even touch on prejudice. They cite the census data stale, that 1/3 of the Senate will be unseated, that there's prejudice to voters, but if you look at the argument, it's just not founded, and it opened the door to challenges to other maps. None of this shows prejudice, because when you talk prejudice in a legal sense, you talk about their ability to defend their case. Their ability to defend their case is still intact. The data should all still be there. The people who were involved are all still there. There is no prejudice alleged that I could see in their reply brief. And certainly nothing that should outweigh the constitutional rights of our voters. Remember, our expert found 52 districts are improperly drawn in this state. Given that we each represent approximately 108,000 voters, we're talking 5.6 million people there who aren't all voters but are constituents, many of whom are voters, and it impacts ultimately every voter in the state when you have that many districts, almost half the total, that don't even meet constitutional muster. The intervening parties are relying on a defense that is nothing more than a mere attempt to keep power and control, while completely ignoring rights of voters and much less looking after their best interests. All this by using a legal technicality.